Welcome to this explainer. Today, we're diving into what is honestly a pretty startling financial reality, one that's silently threatening the life savings of millions of retirees. We're going to unpack the exact mechanics of a federally mandated system called the Medicaid Estate Recovery Program, or MERP for short. Relying on some deeply detailed source material, we're going to expose exactly how this program operates and, more importantly, how it could drastically impact the financial legacy you leave your family. So let's jump right in.
Our source opens with a quote that I think is just incredibly powerful and, honestly, so relatable. "I am never going to a nursing home. They are never taking my house." You know, it's that classic promise made around kitchen tables all across the country. You've grinded through 30 years of mortgage payments and you desperately want to leave that hard-earned house to your kids. It's a beautiful, emotional sentiment. But as the source material points out, without the right legal planning, that promise completely falls apart, both mathematically and legally. To really wrap our heads around this threat, let's look at a specific example from the text. Meet Margaret. She's 78, owns her home, which is totally paid off, and worth about $400,000. And she recently had a minor stroke. A social worker comes over and delivers what sounds like fantastic news. The state is going to provide in-home caregivers to help Margaret bathe, dress, and make meals. And it will cost her absolutely zero out of pocket. Amazing, right? Her daughter happily assigns the intake paperwork. But here is the massive catch. The very second that form was signed, a legally enforceable debt instrument was created against Margaret's entire estate.
And that stealth debt brings us directly to MERP. Now, the Medicaid Estate Recovery Program is not some administrative glitch. It's not an accident. It's a federally mandated feature created back in 1993. Congress basically said that all 50 states must operate a recovery program. So, states are legally required to try and claw back the cost of long-term care services, yes, including those supposedly free at-home caregivers, directly from a recipient's estate after they pass away. It's a system states quietly use to balance their budgets.
Now, you might be thinking, okay, well, this is an issue for folks in their 80s or 90s, right? Nope. Check out this number, 55. According to the source, the recovery clock starts ticking the very second you turn 55. If you take a single dollar of long-term care Medicaid benefits after that birthday, your estate is legally on the hook. And the program? It doesn't care if your illness wasn't your fault or if you paid taxes perfectly your whole life. The meter starts at 55, and it literally doesn't stop until the day you die. All right, let's move to Section 1, the rule of 3 traps, or basically how the state builds this financial ambush. To actually seize these assets legally, the state stacks 3 distinct traps together. Trap number 1 is what the source calls the custodial care lie. See, most people falsely assume Medicare covers day-to-day care, but Medicare actually only covers acute care, things like surgeries or a short hospital stay. It pays exactly $0 for custodial care. That's the day-to-day help with bathing and meals that frail seniors really need. And because full-time in-home care can run you $8,000 a month, families just bleed cash until they are forced onto Medicaid. And as we know, Medicaid is what triggers that MERP recovery lien. That brings us to Trap 2, which is the automatic lien at death. This step-by-step process is crucial to understand. While you are alive and receiving Medicaid, your primary house is safe. It's viewed as an exempt asset. But the absolute split second you pass away, poof, that protection completely evaporates. The house instantly transforms into a probate asset, meaning a court takes control of it to settle debts. The state then steps right in, files a claim as a priority creditor, and demands to be paid back before your kids inherit a single dime. Now, geography plays a massive role in dictating your family's fate here. Whether your house is actually safe depends entirely on arbitrary state lines. For example, California scaled back its program to only target probate estates, which means living trusts are generally safe. Down in Florida, you've got strong homestead protections, but federal law still forces claims through probate. Meanwhile, a state like Ohio uses expanded recovery and aggressively goes after assets that pass outside of probate, like transfer on death deeds. It's a real patchwork.
And then we have Trap 3, which is designed specifically for people trying to outsmart the system at the 11th hour. The 5-year look back. Once families realize the state might take the house, they naturally try to just quickly gift it to their kids. But federal law demands 60 months of financial records when you apply for care. If they see you gave your house away within that 5-year window, boom, they hit you with a massive penalty period. It literally locks you out of Medicaid coverage exactly when you need it most, completely devastating the family financially.
Let's transition to Section 2, the Arthur math. We're going to visualize the real cost of action versus inaction.
So let's put some hard numbers to this, with a 68-year-old guy named Arthur, who has a $400,000 house. This comparison brilliantly illustrates the massive stakes we're talking about. In scenario A, Arthur does nothing. He gets 4 years of care costing about $384,000. When he dies, the state swoops in, takes the entire value of his house, and his kids inherit absolutely zero. Now look at scenario B. Arthur uses a Medicaid Asset Protection Trust. The state still pays for his care, but because the house isn't in his probate estate anymore, the state can only recover $15,000 from miscellaneous assets. His kids end up inheriting the full $400,000 house.
The financial difference here all boils down to an astonishing return on investment. To make scenario B happen, Arthur spent about $5,000 on an elder law attorney to set up that trust. That single $5,000 investment shielded a massive $369,000 of inheritance for his family. That is a 73-to-1 return. As the source argues, there's basically no financial product out there that can touch that kind of return for a middle-class senior.
Which brings us to Section 3, Legal Tools for Protection. Let's look at exactly how to disarm the MERP program.
The really good news from our source material is that you are absolutely not powerless here. Elder law attorneys have actually been using highly specific legal structures for 40 years to disarm these recovery programs. Tool number 1 is the heavy artillery, the Medicaid Asset Protection Trust, or MAPT. This is an irrevocable trust. Because you transfer the house into it, you technically don't own it legally anymore, but you retain the legal right to live there for the rest of your life. When you pass, the house completely bypasses probate, meaning the state's MERP claim can't touch it. But remember Trap 3. You absolutely must fund this trust at least 60 months before applying for Medicaid to clear that tricky 5-year look-back window. Tool number 2 is something called a ladybird deed, or an enhanced life estate deed. This little beauty allows you to pass the property to your beneficiaries outside of probate, but you get to keep complete control during your lifetime. You can still sell it, you can still mortgage it, and because you keep control, it's actually not considered a gift, meaning it legally sidesteps that dreaded 5-year look-back penalty. The one major catch, it's geographically restricted. You can only use it in a handful of specific states like Florida, Texas, and Michigan. Now, for families with larger estates, or if you've unfortunately already burned through some of that 5-year clock, the source points to a combination strategy. This might mix a MAPT for the primary home with stuff like promissory notes, qualified income trusts, or even spousal refusal tactics, depending on your state. Listen, these are absolutely not concepts you just sketch out on a napkin. They are highly complex, legal architectures that require a certified elder law attorney to execute correctly.
All right, Section 4, the cruelty of timing. Let's talk about the reality of the 5-year look-back window.
If you only take one thing away from this whole explainer, let it be this. Timing is incredibly ruthless. These legal tools are amazing, but they only work if you respect the calendar. If you fund your trust at age 68, you then have to wait out a strict 60-month penalty period. It's only at age 73 and beyond that you can finally apply for Medicare care safely. The source heavily warns that the trust must be funded when you feel perfectly healthy. If you wait until you feel sick, or wait until a social worker is already sitting at your kitchen table, it's just too late. The window of opportunity literally closes the moment you think you need to act.
And that brings us to our final takeaway. As the source so powerfully puts it, in this system, you aren't a victim, you are a target. But you have the knowledge and the tools to step right out of the line of fire. The state has unending patience, and they will gladly wait for you to make a mistake. So the ultimate question we're left with is this. Are you going to take action and protect your family's legacy while the window is still open? Or are you going to wait until the state shows up with the bill? The choice is completely up to you.